When you have a child that has a disability like autism or some sort of special needs, as soon as they turn 18 years old here in the state of Florida, you can no longer make decisions over their person or their assets. This means you're going to need to open up a guardianship case. A guardianship case is actually two cases that need to be opened up. The first is a mental health case, and the second is the guardianship case. The mental health case is opened up for the purposes of determining whether that person is incapacitated or not. A guardian can't be appointed for someone who is not incapacitated. So when we open up a mental health case, what we're asking the court to do essentially is to determine the incapacity of that person. When we file our petition, it triggers the court to set a hearing date for that determination of incapacity. And at the same time, the court appoints 3 doctors. These doctors are known as the examining committee. Each of the members of the examining committee go and visit the person who is known as the alleged incapacitated person. And now during the Zoom era, a lot of our examinations have been happening through telemedicine. So through Zoom, through Skype, through FaceTime. But in any case, these 3 doctors visit with the AIP, the alleged incapacitated person, and do an assessment. They ask questions. They get a better understanding of what the incapacity is of that person and the extent of that incapacity. After they assess this person, they file what's known as an examining committee member report. This report details for the court the condition that they found the alleged incapacitated person in, who was present during the assessment, what kind of questions were asked, what kind of responses were provided, and then ultimately a recommendation as to whether this person is incapacitated and to what extent, and what sorts of rights they feel should be removed from this alleged incapacitated person. In addition to the 3 doctors that the court appoints, the court also appoints an attorney to represent the interests of that alleged incapacitated person. If the person who is incapacitated has assets, then the court is going to appoint a private attorney. This is someone who's going to be paid from the assets of that alleged incapacitated person. But if the AIP doesn't have assets or is only receiving Social Security, then the court is going to appoint what's known as kind of like a state attorney, where the state is going to pay for the attorney that represents the AIP, and they're known as regional counsel. This person may also reach out to you as the person in charge of their care and also want to speak with the AIP. The incapacity hearing usually takes anywhere between 1 to 2 months after our pleadings are filed. And it's during that hearing where we review the examining committee member reports, we hear from the court-appointed counsel for the AIP, and the court makes a determination as to whether this person is incapacitated or not. Simultaneously, during these 2 months, we open up the guardianship case. And in the guardianship case, we're letting the court know we have filed this pleading to determine their incapacity, and also we want this person or these people to be appointed as the guardians. A lot of administrative things need to happen inside of this guardianship case. The person has to obtain their digital fingerprints. This is done for the purpose of making sure that the person is not a convicted felon. So in Florida, you have 3 requirements to be the guardian. You have to be 18 or over. You cannot be incapacitated yourself, and you cannot be a convicted felon. So fingerprints are done to make sure that there is no criminal history. In addition to this, you have to also fill out an application, which gives the court a history of your financial and also criminal background, if any, and other pleadings that our firm prepares for you on your behalf. During the incapacity hearing, if all the documents are prepared and filed in the guardianship, the court will ask, is there anyone who has stepped up to the plate to be the person's guardian? At which point we say, yes, of course, Your Honor, and we let the court know whether that guardianship case is complete and ready to go and have the person appointed, or whether there's still certain things missing. In any case, the orders are submitted to the court, and the court makes a determination as to who should be guardian and appoints the person as guardian. Usually it's a mom, a dad, a brother, a sister, a relative, someone who has been a part of that person's life and knows the care for that person. One of the questions that my clients ask me is, well, now that I'm guardian, do I have to take care of this person? And, you know, the guardian is not so much a caretaker as they are the person who's responsible for making sure that that alleged incapacitated person, which at this point they're known as a ward because they have been determined incapacitated, to make sure that the ward is being cared for, to make sure that they're in a safe and healthy environment, to make sure that they have whatever needs that they have are covered, social, physical, mental, behavioral, all of that thing. So pretty much the guardian is kind of like the captain, and they're making sure that the ship is running correctly. Now, after you're appointed as the guardian for this ward, there are requirements that need to be fulfilled. In the beginning, there are initial requirements. We have to let the court know this is what the person has as far as assets, and this is the plan of care that we're going to be following for this person for the next year. That's known as an inventory and an initial plan. And in these documents, we let the court know where the person's going to be living. If a hurricane happens, where's the person going to go? These are the medicines that they're taking, the doctors that they're seeing. It's a very simple form, but it does need to be filled out and filed with the court within the first 60 days. Thereafter, it's a more like a maintenance thing, where you're letting the court know on an annual basis, this is what the person has received, this is what has come out of the guardianship, if there are any assets, or if there's Social Security, then we ask the court to waive the accounting of that Social Security, and it's just letting the court know they received a total amount of this in Social Security, a total amount of this went out, and here's the balance. And then together, we also file an annual plan, which is very similar to the initial plan. And it's just letting the court know for the next year, this is where the person's going to live. These are the doctors. These are the medicines. This is what they can do. This is what they can't do. And that has to be filed by April 1st. So this is a very quick overview on what a guardianship is. Obviously, there are nuances which can make your case a little bit different if people are fighting, if there are different types of assets. And that's what our consultation is for. But for me, I wanted to make sure that you receive the benefit of this explanation before meeting with me, because a lot of the questions that my clients have happen during this part of the session. So I look forward to meeting with you soon.